Original side matter. It will come in list. Inclusion.
The interim order, my lord, has expired on the 31st of March.
It will come immediately.
My lord, may I be permitted to mention for one withdrawal of suit? My lord,
First, let it come in the list first. Is it in the list, today's list?
my lord, it is not
Let
pertaining
it come in the list.
pertaining to Lordship Justice Vishwarup Chaudhary's determination. Justice Vishwarup Chaudhary's
Urgent matter.
urgent matter. Withdrawal.
Let me see.
This is for withdrawal, my lord.
What is the urgency? What is the urgency?
For withdrawal, my lord.
Let it be placed before regular bench unless there is very urgency.
My lord had directed this matter to appear. I've mentioned it before. It is still not appearing in the field. I don't know.
Which one?
What is that? What was the property?
Is it in my determination? Then it will appear in the list.
Right, number 99.
Yes, yes.
I may not be here, but my junior will be there.
May I have my kind to mention that testamentary suit now it has come to a lordship jurisdiction. Now, Millet from it's of 2022.
Item number 22.
No. Millet now it's a testamentary suit of 2022. Millet now Millet has jurisdiction. Millet
Not jurisdiction, determination.
Determination. So sorry. I'm so sorry. I always does something go up. Now first April now Millet. The issue is that Millet the matter was fixed by Justice Rao Millet when Millet had determination on Millet 11th Millet at 3 p.m. Millet the person has already made his arrangements to Millet flight tickets and also visa and all those things to come down and give evidence before this court on 11th. Millet, I was humbly praying may this matter appear before Lordship on 11th. Otherwise everything will be infructuous. Therefore time to
Just a minute.
May it appear on that day.
दिए दो एक डेट देके दिए दो execution will be filed before the executing court. Execution determination I have not. What is the urgency of the matter? Right, we can wait till 11th.
Since August last. It appears only list.
Let it appear for the timing.
But may I permitted to mention that a suit Millet of 2021 Lordship now has a determination Millet.
Item
not appearing in Lordship Millet.
For inclusion.
Yes. Millet, only one thing Millet. Today and day before yesterday and today was fixed for Millet evidence of my witness cross-examination. Witness is in Kolkata. He's from Hyderabad. He's just come for this matter. But he's present in court since yesterday.
Who is your other side?
But I have on notice Millet. Other side is here. I have given notice to both the other defendant. I am for the plaintiff. He's my witness being cross-examined for 2 days were fixed. Today also at 3 p.m. it was originally fixed. Now Millet, new determination for your Lordship. I can only request. But Millet, the witness has come only for this matter from Hyderabad yesterday. Millet, there was a strike.
You will cross-examine.
Defendant number 3 is cross-examining.
You are cross-examining. Who is for the 3?
I know I given a notice. Millet. Mr. Ghosh is Mr. Senior Advocate Mr. Dhruvo Ghosh is appearing for them. I'll intimate.
Talk to him if it is possible. I will file it. I will publish a supplementary list. It will appear today itself.
I'll just intimate him or request him.
If possible, if he comes. Otherwise, it will appear in the list as usual.
I'm present.
Would you cross-examine today?
It was fixed for.
Not in the list.
No, not in a list. I can publish a supplementary list. If you're ready, I can publish a supplementary list. Whether question is whether we are ready or not.
If he is here, he has just come for this matter. So if in this week, Lordship can fix any day.
No, not any day.
His journey would be not justified. His journey
I can
would
fix
not-
tomorrow
Yes, yes.
at best.
Yes, yes.
Because day after tomorrow I'll be leaving Kolkata, so it is not possible for me to take.
Tomorrow, my lord.
Yes,
Otherwise, his entire purpose of coming here.
fixing it tomorrow.
Grateful. I am handing over the last order sheet by which was fixed and the mentioning notice. Grateful.
Inclusion.
Revocation matter, my lord. Word substantially put to justice now on 9 occasions on the verge of completion. Now,
I am releasing it.
my lord,
Let it come in the list first.
my lord, given the number.
My lord, may I be permitted to mention one probate matter, my lord,
For inclusion,
Yes.
give it. What is the urgency? That is separate issue. What is the urgency today itself? Why it should not be placed before regular bench? We have to wait for couple of days only. 11. Determination is still 11. Unless there is urgency, there cannot be.
Your Lordship, may I be permitted to mention a matter for correction of orders? Your Lordship,
Let it come tomorrow.
Order site, item number 1 to 3.
Lord, I'm in a better, Lord, I'm in a better position today.
Have you paid something?
Yes, no, Lord, I mentioned, Lord, Your Lordship, because Your Lordship had directed, Lord, us to, Lord, deposit, Lord, 50% of the awarded amount, Lord, in cash with the registrar. A balance amount, Lord, was to be given by bank guarantee. Lordship had given us time, Lord, we couldn't do it. Yes, Lord, and balance amount was to, Lord, we couldn't, Lord, give it within the time. Lord, Your Lordship, Lord, had on the last occasion, Lord, on Mr. Mukherjee's prayer, Lord, there was an amount of about 3 crores lying in the account, Lord, which we had disclosed in our application, Lord, that was said to be asked, directed to be attached. That was the prayer, that was the order passed, that it should be attached. But not in the order, Lord, it has gone in that the entirety of the account has been attached. So, Lord, though we received not funds from the state, Lord, not for complying with the Lordship's order, Lord, by depositing and, Lord, punishing bank guarantee, Lord, we couldn't because, Lord, the entire amount is lying attached. So, Lord, what I'm respectfully submitting, Lord, kindly, Lord, permit me.
File an application, I will pass an order.
Lord, I was only saying, Lord, Lordship permits me to operate the account for, Lord, complying with your Lordship's order, Lord, for the, Lord, there's no difficulty in doing that. Lord, I
How
will,
much have you deposited?
Lord, I have to deposit, Lord, I'll give you Lordship.
Recorded in your Lordship's order.
আরে কত জমা দিতে হবে draft
1 lakh.
yes so Lordship,
What
Lord,
is the amount in the account?
Lord, it is, Lord, amount is not including the bank guarantee, Lord, that's more than 6 crores. So, my Lord,
Come to your Lordship's
my Lord,
order of 26 September.
Yes, my Lord.
Exact amount has
my Lord,
been.
so my Lord, Lordship permits me, my
Where
Lord,
is
to
the
operate
order?
the account, my Lord, to deposit, my Lord, a sum
Let
of,
me see. What is the order of attachment?
Order of attachment.
Lord, I have just handed over to you, Lordship.
10th March
Commissioner.
10th March 24.
25. Last day.
My Lord, your Lordship says, my Lord, page 2 of your Lordship's order of 26 September, my Lord, 50% of 6 crores 2 lakhs 45, which will be about
Yes, it
3
is
crores.
stands attached and freezed.
Yes, so the entire of the account, my Lord, that is the account where the funds have come.
So I can pass one order modifying this one.
Your Lordship permits me, my Lord, to operate the account for the purpose of compliance of your Lordship's order. My Lord, I think that will not be sufficient.
Or on the other hand, bank may be directed to deduct an amount and send it to their account.
My Lord, I have to make a bank draft and send. My Lord,
Need not be. Your account is attached.
Lordship.
Certain amount is you have to pay.
Yes, my Lord, 3
Right
crores
now.
1 lakh.
3 crores
So
1
your
lakh.
Lordship may direct the bank, my Lord, to issue a bank draft in favor of rest of
Or
side.
bank will transfer the account to the registrar's account.
Lord, I don't know whether they not accept, not they will want a draft. Lord, we have tried in past, not transferring online. Lord, I think that facility is still not there in our court. So, Lord, if Lordship,
Draft in
yes,
favor-
Lord, yes, that's what I'm saying. Lordship may direct the bank to issue a draft in favor of the register side for rupees 3 crore 1 lakh 22,000.
26. This is the exact amount.
Where is the exact amount? Is
Lord,
there
it is
anything
50%
mentioned?
of 6 crore 2 lakhs. Lord, I think Mr. Kankari has calculated.
01 22996.50.
So, Lordship not permit me not.
Awarded 6. 0245,993. That was
Not
awarded amount.
Yes. So not 50% will be 3 crores to 1,22,996. So not that will not I'll
Put in writing.
yes,
Give me.
so not that will not transfer not
Bank will issue a bank draft.
in favor of registrar Roger side for this amount. And will not Lordship will not gives me will not 4 weeks time will not to give a bank guarantee for the balance amount will not by operating the same account because will not I'll have to will not deposit that money with the bank.
Up 50% This is the exact amount.
Bank draft in respect of this amount.
Yes.
Of this amount, yes, yes, Lord. And the same amount will be bank guarantee, Lord, which we shall also furnish.
50%
Of 6 crore 2. That comes to this amount.
being 50% 50% of 602.
60, yes.
That
301 and Lord, 45 lakhs is about 23,000, 22,000 something.
So out of this amount, you will make bank draft for
201.
whole amount bank draft.
Yes. And the other balance amount is bank guarantee.
Yes, not built. Lord, bank draft, Lord, we shall get not immediately. Lord, she gives me just a week's time. And Lord, bank guarantee, Lord, within 4 weeks.
I am passing direction to the bank. You prepare a bank draft in the name of register original site. That will be sent to him, registrar. In terms of order dated, today you have no resolution.
No.
Order dated 10th March 2025.
It has been clarified that there will be no resolution, Lord, concerning other courts. Not only one learned judgment, when as and when his lordship comes, Lord, it will be confined to him.
Bank account of the judgment debtor being HC number ওটা দিয়ে দেবে এখানে দেওয়া আছে HC number maintained in Central Bank of India New Market branch was freezed and attached. Full stop. Mr. Sinha, the learned senior counsel appearing for the judgment debtor submitted that unless
Lordship is submit, but the state has sanctioned the amount and the amount is lying in the, has
that
been
the
transferred.
state has sanctioned the amount,
And the amount is lying in the account.
unless the order of attachment and freezing is lifted, this account cannot be operated
To comply with the directions
to
dated
comply with the direction dated
26 September 2024.
26 September 2024. Full stop. The learned counsel, Mr. Mukherjee, the learned senior counsel appearing for the decree holder, and Mr. Shen, the learned senior counsel appearing for the same
Award holder.
award holder, submitted that they have no objection, subject to the condition that sufficient arrangement should be made for compliance with the aforesaid order dated 26th September 2024. Full stop. Next para. The branch manager, Central Bank of India, New Market branch, is hereby directed to prepare a demand draft of the banker's check in the name of
Registrar or inside.
register original site. একটু চেক করে নেবে কি নামে হবে ডিমান্ড ড্রাফটটা রেজিস্টার অরিজিনাল সাইট এটা চেক করে তারপরে লিখবে কিন্তু রেজিস্টার অরিজিনাল সাইট উইদিন কোড পরে সাম অফ রুপিস এইটা লেখো and shall send the same to the register original site. Full stop. Next para. Since assurance given by Mr. Sinha, the learned senior counsel, full stop, comma, the order of attachment as well as freezing is lifted only subject to the condition that he will furnish a bank guarantee within
4 weeks.
within 4 weeks for a sum of rupees same amount.
Same amount.
এই অ্যামাউন্টটা লিখে দেবে। Full stop. To this extent, the order dated 10th March 2025 stands modified. Fix the matter.
Not 4 weeks not takes us to the end of month, Your Lordship. We need it thereafter, Lord, so that we can, Lord, report compliance.
5th May
5th, grateful,
for further hearing.
Lordship.
Millard, only one Millard, further direction Millard. The Millard amount which is to be deposited in Millard by way of banker's check Millard in favor of the registrar, Millard, that should be encashed and Millard put into an interest bearing fixed deposit. That amount.
On receiving the check, banker's check oblique demand draft, the learned, no, let report come from the learned register. Then I'll pass order.
And Millard, kindly fix a time within which that should
Yes.
be done.
The bank shall prepare and send the banker's check oblique demand draft to the learned register original site within 2 weeks from today.
Grateful.
The learned register original site shall forthwith furnish a report to this court on compliance with this order. Not 2nd May. ওটাকে
Would Millard kindly prepone that. Millard,
yes,
grateful.
yes. For that only,
Millard, 3 weeks from date Millard, whatever Millard. Only Millard for recording.
23rd April. Fixed 23rd April for furnishing of the report
Very grateful, Your Lordship.
and further order. This is item number 1 and 2.
1 and 1.
What is 3?
There is one execution also.
134 and 130. This is the third order on the 36.
One is ECCOM 132
So that will also appear Millard depending on whether they comply with it or not.
and EPICOM 37.
That's the 36-2 Millard in this matter. Millard, all three can appear Millard on the 20.
All right.
37 is the section 34.
EPICOM 615. No, 37 is section 36.
34.
34. Okay. 615.
36-2.
36.
And
Okay.
Millard, the others execution. All three can appear.
All the applications shall appear in the list on the returnable date. So fixed.
Item number 4,
Item number 4, I am ওটা হচ্ছে ইয়েটা যেটা ওই intervention application. Lordship, in our section 34 application and intervention application has came forward. Today is the date fixed for taking up the intervention application.
What is EPICOM 40 then?
Lordship, this is section 34 application filed by my
Same award.
Lordship.
No,
The
different.
premises are same. Two separate proceeding was initiated, separate order has been passed. We also filed section 36(2) application. That matter will appear on a later date. There is direction for our part, comply with the direction. Now today, your Lordship has segregated the intervention application
That
filed
is
by,
JCOM 1.
yes.
Exchange of affidavit is complete.
It is by the intervener claiming that
Who
they
is
are,
the intervener?
Lordship, they are claiming that they are the original owner of the premises.
Intervener, name of intervener is?
Punalur paper mills.
The same.
Oh.
I'm the original management of Punalur paper mills.
Later
Management.
But I'll tell you, Lordship, what had happened. Millard, Punalur paper Millard has always Millard owned these properties Millard, which were Millard acquired by the state. Millard, the acquisition Millard was Millard, first Millard done Millard without payment of Millard compensation. Millard, thereafter Millard, Supreme Court referred the matters to arbitration. Arbitration Millard, awards are in my favor. In the meantime, what
You are
Punalur Millard.
You are Punalur.
Yes, Millard, what happened was, Millard, while Millard, all this was happening, Millard, Punalur's Millard shareholding Millard was sold out. My lord, two, my lord, the persons who claim to be the present management of Poonal. My lord, on the basis, my lord, of irrevocable power of attorney, granted, my lord, to my lord, my clients to enjoy the usufructs, my lord, of my lord, the award. So, my lord, now Poonalur is coming and saying, no, I should be allowed to enjoy the usufructs of the award. They tried, my lord, before, my lord, the learned arbitrator, my lord, that also failed. My lord, because, my lord, the learned arbitrator came to the conclusion, my lord, that this was, my lord, a irrevocable power of attorney insofar as, my lord, this litigation and the usufructs of it is concerned. Now they have applied before your lordship. Now, my lord, the first thing, my lord, is, my lord, in any view of the matter, the challenge to the award, my lord, has to be, my lord, decided first. My lord, once that is decided, my lord, then your lordship can decide this, or if they want to do it today, I have no problem.
Would you start today?
But we can, but the difficulty is Lordship has fixed the other matter on 23rd, as we have heard. But kindly takes up both the applications are same.
No, your lordship has segregated
Your
these
lordship,
matters
yes.
because on that day, the section 34 application and 36(2) are fixed. In order to segregate, your lordship has fixed a separate date for taking up the intervention application.
But there are two matters in which there are intervening
You can do one thing instead of 20, I fix 23rd. Come on 22nd.
Lordship,
GACOM 1 of 24 filed in Epicom 40 of 2023 will appear in the list on 22nd May
yes, let you know, wait, good.
for hearing. Let us start on the eve of holiday, eve of vacation. We'll start hearing. No, that I fixed on April.
April.
The other one's in April.
Oh, then 22nd April, sorry. 22nd April.
But APCOM 37 was due to appear before your lordship on 4th
4th
of this month, that is day after tomorrow.
day after tomorrow, I will not take up matter.
But that was modified because they hadn't paid. Lordship's given, my lord, them a last chance. Where, my lord, the learned advocate general appeared. Lordship, my lord, gave them a last chance, let that money come in.
But
Without the
there is
money-
also an intervening application pending in that.
I will take it up on that day. But possibly 4th April, I'm telling you, I will not be able to take up matters.
Lordship has to fix it at any time that.
Yes, because I will be leaving Kolkata.
But do we file the affidavit in reply in connection with the AP 37? APCOM
Ready,
37? That is ready.
That's
We have
why
already-
what I asked. Affidavit in reply filed in GACOM 1 of 24 be kept in record.
No, this is in another matter.
But this is the other matter.
This
No. This is
is
এটা
37.
এটা অলরেডি চলে গেল আগের যেটা ছিল
Very well.
এটা আগে
Come on the next day.
Let it-
ছেড়ে দিন, ছেড়ে দিন।
not in this matter.
ওটা কেটে দাও, reply।
22. GACOM 1 on 22, 1, 2, 3, item number 1, 2, 3 on 23rd, item number 4 on 22nd April.
Item number 5, 6, and 7. Rampuria Industries.
There are two suits before your lordship. One is part-heard and the other is specially assigned. In fact, it is our case that the two suits should be heard analogously. In the meantime, in their suit, my lord, they have taken up two applications. One is judgment upon admission and one is under order 13A. My lord, the summary
Application.
judgment, summary matter, my lord, has been
I have heard it extensively.
heard it extensively. It was our turn, my lord, to address your lordship.
Yes.
Now, my lord had also asked us to prepare a note. Now, I find, my lord, through some misunderstanding, the note has been prepared for the judgment upon admission application and not for the chapter order 13A application. So I can
Summary judgment
yes.
and judgment of admission.
My
That
lord,
is
we're hearing
GA3.
the summary judgment matter.
GA4 is summary judgment. GA3 is judgment of admission.
G4 is summary judgment.
And GA5 is
My suit, my application for hearing, my lord, both the suits analogously. If the order 13A succeeds,
then it will be redundant.
then it will be redundant. If it does not succeed, then, my lord, both the suits will have to be taken up together. But my difficulty is My lord, the note which has been prepared for your lordship is for the judgment upon admission. I can start on the order 13A with my affidavit in opposition, which, my lord, I personally feel, my lord, it will be a double submission to your lordship. My lord, here's it on another day, my lord, I could come ready with the note.
Just a minute.
My lord takes my affidavit in opposition then. May I just show your lordship, my lord, what my stand is? Because there are subsisting orders in this matter, which goes to the very root to tell your lordship and assist your lordship to the effect that perhaps the order 13A, my lord, is not printed.
Yes, tell me.
But kindly take the affidavit in opposition filed by Govindaram Goenka, affirmed on 15th July 2024. Subject to correction, my lord, this is the affidavit in opposition filed by Hindustan Wires Limited in the suit filed by Rampuria Industries and Investments Limited. My lord will straightaway come to paragraph 3.
Hmm.
The plaintiff instituted the instant suit in the year 2011. Soon thereafter, in November 2011, the defendant filed his written statement in the suit vehemently denying and disputing the alleged claim of the plaintiff. Long prior, well, this is a very important point. Long prior to the institution of the instant suit, the defendant in the year 2000 filed a suit in this honorable court, being CS number 273 of 2000, for a declaration that the defendant is a monthly tenant under the plaintiff in respect of the suit property and for various other reliefs. For various other reliefs, my lord, includes a prayer for administration of the property. This suit being CS number 273 of 2000, so mine is the prior suit. Mine is the prior suit. Now kindly see the orders that have been passed in this matters, my lord, from time to time.
This is in respect of GA4, that is summary judgment.
Yes, GA4's summary judgment.
মানুষ
Yeah, see.
এটাকে একটু শুরু করো তো, এটা একটু লিপটাকে শুরু করো। So against summary judgment, what is your plea?
Yes, my lord, it's necessary to show your lordship certain orders which were there prior to the summary judgment application being taken up. I was reading paragraph 3B.
3B, yes.
Yes. So, my lord, my prior suit had been filed in which I had claimed to be a monthly tenant under the plaintiff.
That is 273 of 2000.
Yes, 2000. And my lord, the prayers in their suit is for eviction.
You are the landlord or tenant?
I'm the tenant.
Tenant.
Although the writ of summons in the defendant's suit was served upon the plaintiff, but the plaintiff did not file its written statement in the defendant's suit. That is my suit, which is the prior suit. In July 2016, the plaintiff proceeded with the trial of the instant suit, and by an order dated 4th July, this honorable court was pleased to frame issues in the instant suit and directed the instant suit to appear in the list on 18 July. So issues were framed. Issues were already framed, and the suit was felt and decided and agreed upon to be tried, my lord, as an adversary proceeding. A very important aspect in my very humble and respectful submission to be kept in your lordship's mind. On 18th July, my lord, I'm in subparagraph D, the plaintiff filed evidence on affidavit of Vinod Rampuria, which was taken on record. The advocate appearing on behalf of the defendant brought to the notice of this Honorable Justice I.P. Mukherjee about the defendant's suit against the plaintiff and submitted that both the suits, that is to say, the defendant's suit 273 of 2000 against the plaintiff and the instant suit, relate to the same suit property and should be heard together, and that the advocate in the record of the defendant had already filed an application for assignment of the defendant's suit before the Justice I.P. Mukherjee so that the suit may be heard together. This assignment has since taken place. In that view of the matter, the Honorable Justice I.P. Mukherjee was pleased to adjourn further hearing of the instant suit till August 1st, 2016 for ascertaining assignment position of the defendant's suit. In the meantime, the defendant's suit was assigned before the Honorable Justice I.P. Mukherjee. On 9th August 2016, both the suits, that is to say the instant suit as well as the defendant suit, appeared before the Honorable Justice I.P. Mukherjee, when it transpired that the plaintiff had not filed its written statement in the defendant's suit.
I have seen this, sir. Let me understand one thing. Why judgment or summary judgment? Just for refreshment. Why summary judgment? Mr. Dotto, what have you stated? Summary judgment? The reason for passing summary judgment. No, in application.
Summary judgment is, I think, affirmed sometime in June 2024.
No, what are the grounds for passing summary judgment?
For the respect of the property, and it has expired. The suit in which he has filed clearly claims that the rent is above 10,000 rupees,
11,000.
11,000, and he received the notice under our basis. Beyond that, I don't need to show anything.
What did I have given evidence and at least tried to refer to the evidence that I'll be relying upon to show that I'm still protected under the West Bengal Premises Tenancy Act, the old act.
No, where have you stated? Which paragraph you have stated this?
Your Lordship is looking at the notes of the judgment.
No, this application.
If your Lordship comes.
3031 is there.
26 onward. Or with the paragraph 27, prior to the filing of the respondent had filed an application 6-1 of the premises. Your Lordship got it, Miller?
28, basically 28.
27, 28. So the
This is your plea.
rent is 11,000, lease has expired, and 106 notice served and received to that. And I have, in my notes, I have given judgment sooner, where the Apex Court has now said that after receipt of notice, nothing remains to be tried in the suit. That's the only point that has to be addressed.
And 31, 32, up to this.
Paragraph 7 of Miller by judgment of
Paragraph.
Miller, if your Lordship has the notes.
Notes are देखिए एकटू. You are referring to?
Your Lordship is fine that
File vision.
paragraph 7.
Para 8, you showed para 8. 7 and 8, both.
By our the notes.
That you have mentioned here. Paragraph 6, paragraph 10 you are referring to. Signotron.
This was the judgment of it. The dependent agents submitted position that the lease has expired. The dependent agents was notice under Article 6. And the rent is above 10,000.
So this is your point, I understand.
Well, kindly see how I've dealt with it in paragraph 20. I have a lot to say on this, when so far as
Yes.
judgments are concerned. Kindly come to paragraph 20 of my affidavit in opposition. At page 22. Regarding paragraphs 24 to 28 of the
You are referring to paragraph 20.
Yes, I'm referring to paragraph 20. I say that the plaintiff is totally silent on the defense raised by the defendant in its written statement that the composite rent of 11,000 paid by the defendant to the plaintiff included not only the rent of the suit property under the 56 Act or the 97 Act, but also included occupier's share of municipal tax and a property tax, as also maintenance charges. And consequently, the rent under the 56 Act or 97 Act is much less than rupees 10,000 per month. And the defendant is entitled to protection under eviction first.
So this is your first point, that rent is actually not 11,000, it's much less.
It's less than
8,000.
10,000.
So this is a question of fact, cannot be decided.
Cannot be decided here. My lord, I have developed.
You said 8029.20.
8029. I have given the breakup, my lord. I've given the breakup on page 16. Rent of the suit property is 8029. Maintenance charges is 802. Occupier's share of municipal taxes and a property tax payable under the KMC Act, being 27% of the rent, is 2168. That comes to 11,000. Now this is.
Where is the agreement for rent? The agreement of lease or license, whatever that might be, or tenancy? Page 28.
Page 20, section B of their petition.
Then what is 28 in AO? Page 28 in AO. Is it the agreement?
Yes. I'm correct. Typed it out.
29th day of June, 1972. Rampuria Industries and Hindustan Works Limited.
Just grant me a moment, my lord. I just check this one moment. There must be a pleading of this.
No, this is lending agreement, I think.
Yes, loan agreement.
Loan agreement.
It's the loan agreement. Six, my lord. That is by
Same thing. There's a simultaneous execution of loan agreement and tenancy agreement.
Yes. My lord, we gave them money for construction. My lord, my affidavit in opposition will have to be placed in some detail, my lord, because these are facts which your lordship will have to go into. And I dare say, and with the deepest of respect and with all humility, it cannot be done in an order 13A like this.
Yes, yes, I will hear you. Let me see. Let me understand the case first.
I've said, my lord, 29th June, two separate documents were executed between the plaintiff and the defendant. In page 6, 4, subparagraph 3. This is the case. In fact, paragraph 4, my lord, I have those matters recorded as a question of fact which have to be gone into, my lord, before your lordship goes into the order 13A. 29th June, two separate documents were executed by and between the plaintiff and the defendant. Under the first document, dated 29th June, the defendant agreed to grant loan of 1 lakh to the plaintiff so as to enable the plaintiff to construct the 5th floor of the building. Those were the days, my lord, where it could be done for 1,72,000. The plaintiff has deliberately suppressed the first document dated 29th June. I've annexed the loan agreement. Under the second loan agreement, also dated 29th June, the plaintiff agreed to let out the entire 5th floor of the building to the defendant immediately after construction, which was to measure about 5,000 square feet. Second document. The document contains terms of the tenancy of the suit property. This document clearly shows that the rent of the suit property was fixed by and between the parties at the rate of ₹1 per square foot per month, amounting to ₹5110 per month. Clause 2.2 of this document provides that the lessor, that is to say the plaintiff, will bear the entire municipal tax, both owners and occupiers share after the first assessment. This document shows that the rent payable by the defendant to the plaintiff included the entire property tax, both owner and occupier share after completion of construction. These are facts which I dare say, my lord, your lordship will have to go into. Look into the agreements. Give a reasonable interpretation to the agreement, which can only be done upon evidence. So, my lord, subparagraph 4, The defendant lent and advanced a sum of rupees 50,000 to the plaintiff, and thereafter on 24th November 72, the balance 50% was given. Construction was completed in or about December 72. My lord, I am on page 8. Plaintiff made over acquired vacant and peaceful possession of the entire 5th floor of the building to the defendant, and the defendant became a lawful monthly tenant under the plaintiff in respect of the suit premises and the terms and conditions. 1 lakh was repaid by the plaintiff to the defendant by adjustment against rent, although the loan agreement stipulated for payment of interest at the rate of 7.5% per annum, yet the plaintiff did not pay any interest. The defendant states that the plaintiff constructed the suit premises out of the funds provided by the defendant, and in that view of the matter, the defendant is entitled to special privileges and equity, and the plaintiff is stopped from terminating the tenancy. In any event, plaintiff company is under the management and control of Rampuria family. In March 91, Moolchand Rampuria, father of Vinod Kumar Rampuria, who signed and verified the instant petition on behalf of the plaintiff, who was then looking after the affairs of the plaintiff company, had contacted me, as at that time I was looking after the affairs of the defendant company. Sri Moolchand Rampuria informed me that the tenancy of the defendant over and in respect of the seat property was created in the year 72, and subsequent thereto there had been substantial increase in the municipal and the property tax, substantial enhancement in electricity charges. Sri Moolchand Rampuria requested me to enhance the composite rent to 11,000 per month. That's, my lord, the breakup will have to be gone into to come to the conclusion whether I'm entitled to protection under the concerned act. Thereupon, I informed Sri Moolchand Rampuria that the duty hour of the liftman operating the 8th floor. That is where, my lord, my facts come into the picture, where I've asked for administration because the property was not being properly maintained.
What was the intention of the parties? Whether rent should include municipal taxes or exclude municipal taxes?
I shall place, if necessary, my lord, all the relevant clauses. But, my lord, the very fact that the parties on affidavit, at least the defendant on affidavit, is saying that this is what the breakup was meant to be, this is something which will have to be found out and, my lord, got as and by way of evidence from the witness who's going to give evidence in the matter. The intention of the parties as it has fallen from my lord. So many other factors, my lord. You just cannot throw me out at your will and fancy. Mine is a prior suit. Issues were framed. Both the suits at one stage were supposed to be heard together. You did not file written statement. You took time to file written statement, excess time to file written statement. It was filed. Then after much difficulty, I've got my suit assigned. Both the suits are before your lordship. And now in the teeth of these sort of facts, my learned friend comes up with an application for Order 13A, in spite of having made an application for judgment upon admission. Well, let's kindly keep it for another day. I shall distinguish the judgments made by my learned friend.
First, factual aspects of the matter.
Yes.
What the parties intended.
Yes.
Because I find one clause that this agreement shall come within 1956 Act.
Yes.
That is in page 11 of the agreement, para 6.
Yes.
Notice to quit in terms of 13(1)(j) of West Bengal Premises Act. In the event of termination of lease, efflux of time, so and so. That point is to be clarified. Para 3, para
7 Act, my lord, right? My case is protected.
So that you have to argue.
Yes.
What is the intention of the parties? And I will also hear from Mr. Dotto. Hard. Mr. Bush, the learned senior counsel. This is the I'm hearing GA4.
GA4 of CS number 690.
Hard, Mr. Bush, the learned senior counsel in part. The applications will appear in the list for further hearing on. How long would you take?
I leave it to my lord, End of April.
My burden is lessened now.
We are already in April. You make it sound as if I'm talking about December.
Second week?
My 11th onwards, my lord, there is a holiday gap after
After that.
after the 17th of April. 18, 19 to Saturday, Sunday.
I will not come.
No. I will not come.
22nd का देखो, first after 22nd तो नहीं. 22nd, because what happened? Suddenly criminal matters are taken up. Tuesday and Friday first half was dedicated for criminal matters. Now there is a vacuum. Once all the criminal matters are
Very
withdrawn.
welcome vacuum so far as we are concerned. Very welcome vacuum. In fact, we went and complained about it.
22nd April.
Very grateful, man.
I always love to hear civil matters. Of course, criminal matters. 14 is there.
The other applications are there.
What is 14 then?
There's and another.
So that's our suit which has been assigned, in which we've taken out an application that both the suits should be heard under risk. Well,
This also. This also. Otherwise, we'll lost track.
Yes.
এটা 14 আইটেমটা তো দিয়ে দেবেন. Same day, both will come. That would be convenient.
All four should be there. Your lordship,
Because let it be decided whether judgment on admission will be there or not.
all four would be there.
Item number 8. Ajay Kumar Agarwal.
I came to this court this morning very happily because in my mind I had some other thought. This did not happen.
How long that will continue? How long? We have issues, we have demands, but that cannot be a procedure which can be adopted and followed in a long term. But it's what I personally. My application under Order 7 Rule 11.
I heard it.
Yes, Lordship has heard it.
I have concluded.
Mr. Bose has concluded. I will give my reply and I will on the next day file my point of limitation. Highly Miller takes up my application. I will give my reply, short reply today, dealing with the judgment cited by Mr. Bose, and I will file a formal book on the list.
You will file notes of argument. You will file.
I will file. But just let me clarify the position in 5 minutes for the reply.
But I will only request my judgment go into too much of facts.
No, certainly not. Certainly not. Certainly not. Certainly not.
Your point is limitation from the averment of the plaintiff.
Yes. Highly Miller takes up the application once for a twofold claim. Just 2 paragraphs.
14/3/2010
Yes.
is the starting point.
Yes, absolutely.
And suit was filed.
It was filed after the period of 3 years. May 2013.
May I have your option? My learning junior is here.
May 2000.
29th April 2013.
Yes.
Now, taking the Miller from the Limitation Act, Miller, on the case of it seems as part. Article 14 I placed. Yes. For the price of goods sold, possibly Lordship has taken more.
Yes.
And delivered when no fixed period of credit is agreed upon. So the 3 years. That's the commencement. But what they have argued, Miller, they say that kindly comes to the next page, Miller. They have referred to Miller. Kindly takes up the claim answer. They have referred to a date of 15th December 2000.
Yes.
That is paragraph 5. And they submitted that the commencement should be on and from that.
And that's why it is within the period of limitation.
Within the period of limitation. Our contention was their claim is based on supply. Supply allegedly made, bills raised, non-payment. That's their claim. That's the first claim. Kindly come to paragraph 8. Second claim is also based on supply because they had to deposit a certain sum of money as earnest money, which allegedly we have not refunded. So that is also based on supply.
So their claim is twofold, 1, 2, and 3, paragraph 8. They have clubbed it together and claimed 54,74,380. Paragraph 8 of it. So their argument was, Millard, that it needs to go to trial. Prima facie, it is not evident their claim is time barred, and limitation since, Millard, it's a mixed question of law and fact, it has to go to trial. That is sum and substance of their argument. But our contention was commencement of cause of action is very important, and the claim based on which fact that is very important. And this Honorable Court Lordship has delivered, Millard, a judgment, Millard. I have also placed it that on the face of it appears the claim is barred, Millard. There is no need to go to trial. And I have cited few judgments, Millard, in support of that. And the important fact, Millard, is the cause of action. Lordship will find, Millard, surprisingly in this plain, Millard, there is no averment to the cause of action. And that has been done deliberately. Kindly see paragraph 10, 11, verse 20. Generally, in all plaintiff, Lordship will find an averment is made just to save the limitations. When did the cause of action arise? The commencement of the cause of action. That is surprisingly missing in this claim. 7, except an averment, the claim is not barred by limitation. Not a whisper about the commencement of cause of action. And I dare say, Millard, this is a deliberate ploy, Millard, to avoid, Millard, knowing fully well their claim is barred. Their claim is barred. And the next one, what they say is 14 December 2010. That is also an important factor. Because Lordship will find from paragraph 5 of the claim, because now Lordship will only have to see the claim, not the defense, whatever I have said. I have cited the judgment also. Section 3 of Limitation Act.
Settled law.
Settled law. Paragraph 5, they have referred to a letter and also referred to a report. And based on that report,
that you have argued last day.
Yes.
That you have argued last day.
Based on that report, LS deduction has been made on account of honest money for which they have claimed refund. And that report, the challenge procedure is, the moment you say I am entitled to claim refund and there is ambiguity in the report has to be challenged, which you did not do deliberately. And Millard, for challenging a report limitation period, say 1 year, Millard, article 100. In both ways, I submit you are out. Article 100 is very clear. When your claim is based on a document, the document has to be challenged on the face of it. And you don't do that. Just mere saying that it's a mixed question of law and fact, it needs to go to trial. No, that is not the factor. You have to show when did the cause of action commence. And also the all factors you have to place before the court, at least in support of your contention, what has been stated in the plaint. It's totally based on supply. And they have referred to a document, notice inviting tender. Even that document, if Lordship considers, though I say cannot be considered because that's not a part of the document which has been annexed to the plaint. Only the plaint and the documents annexed to the plaint, that has to be considered. That NIT has not been annexed at all. But they have relied on that. And I dare say, on the basis of that document also, it should be evident there is no fixed period for payment. Credit, no fixed period of payment. Now, this is on factual aspect. Now, kindly takes up the judgments which they have cited, just 2 minutes everything. They have referred to 6 judgments. And some of the judgments in my humble submission supports my contention. Kindly takes up 2023 SCC online, Supreme Court 1407. Justice Narasimha and Justice William. Kindly comes to paragraph 23.
Just a minute.
13 and 23.
This is an application under Order 7, Rule 11.
Yes. This judgment they have cited to show that a meaningful reading of the plaint is required.
This is settled law.
Yes, 23.13. Now, they have also argued, well, Lordship might recall, that the suit was filed long back, there was a decree, Order 9, Rule 13, recalled, witness was in the box. So, this application seems to have been filed just to delay the progress of the trial. That's not law. 23.14, kindly see, it supports my contention. The power under Order 7, Rule 11 CPC may be exercised by the court at any stage of the suit. At any stage, either before registering the trial or issuing summons or before the conclusion of the trial. So I have come before your lordship before conclusion of the trial. This supports my contention, what I have submitted at the threshold. Meaningful reading of the plaint, absolutely, no doubt about it. But you have to disclose your right.
Order 7, Rule 11 can be exercised.
Any point of time and before conclusion of the trial. Their judgment 23.14, totally contrary to what they have submitted. Just to prejudice the court, of course, I believe.
This was decided in?
Decided in 2003, one Supreme Court cases 557. I have also cited a judgment showing that it can be done at any point of time.
That was referred to in Salem Bhai.
Yes.
That is decision of Salem Bhai.
Salem Bhai. But it has been quoted, Miller, here. So it supports my case, Miller. And I don't dispute about the proposition of law, what they tried to argue, Miller. Meaningful. Yes, has to be meaningful. I also submit that. Just because in one paragraph you said 14 December, just to indicate that your claim is within the period of limitation, that will not help you because your cases and your cause of action commencement is really non-supply and non-payment. Supply made non-supply, that's the cause of action. Just adding a paragraph and adding a particular claim that my claim of earnest money is there, therefore I'm through. No. And that is also based on a report which you haven't challenged. And the law says that it has to be done within a period of 1 year. Just a deliberate ploy to just to save the period of limitation, bro.
All right, I have heard you.
Just another, there are two other judgments kindly takes note of it. 2000, just hurriedly, 2015
Page.
volume 8 Supreme Court cases 331.
No, the page of this argument, notes of argument.
I have filed it, I will file it.
No, the notes of argument of the defendant, of the plaintiff.
Plaintiff, I haven't, they have filed it. They have not given us a copy, but I don't require, they have filed it.
Which judgment you are referring to?
First judgment which they have handed over, I do not know the page. 2023 SCC Online Supreme Court I have shown 151407.
Eldeco.
It's Millard. Gita versus Nanchun the Swami and others.
This you have just now referred to.
Yes, they have cited that.
Yes, this you have just now referred to.
Now I am referring to another one, 2015 volume 8 Supreme Court cases, which they have also referred to. That is P.
Guru Raj. 2731.
2015 8 Supreme
Yes,
Court
27.
cases. I do not know at which page because I haven't been favored with a copy of the notes. That's why I am placing the judgment.
Yes, 27.
Paragraph 5 they have said. Paragraph 5 kindly considers. I am not disputing this. Kindly comes to the last sentence of paragraph 5. It is only if the averments in the plaint ex facie do not disclose the cause of action or on a reading thereof the suit appears to be barred by any law of the plaint can be rejected. In all other situations it has to be adjudicated. I say absolutely I agree with the proposition. I say from the averment it's ex facie is barred by limitation. That's my contention. The next one which they have cited 2022 volume 7 Supreme Court cases.
2022 Vishwanath Banik.
Yes, paragraph 7, Lordship kindly comes to
You are referring to?
paragraph 7, possibly they have referred to this paragraph, kindly comes to
Paragraph 7.
Yes, now so far as Lordship has got it. Now so far as the issue whether the suit can be said to be barred by limitation at this stage, what is required to be considered averment in the plaint. That's true. I'm not disputing this. Only in case where on the face of it seems suit is barred, then only the plaint has to be rejected. And I submit it's on the face of it appears that's an ex facie barred. What the court has to consider, what is the commencement and why there is no pleading about the cause of action. That 14 December 2010, one paragraph is not enough, Millard, to submit
that you have explained.
Yes.
Prima facie meaning and meaningful reading of the plaint very clearly shows it is barred.
The other one which they have cited, 2017 volume 15 Supreme Court cases 5-2. Paragraph 3.
2007
volume 15 Supreme Court cases, page 52.
Jageshwari.
Yes, that is not somehow I don't think it's applicable. Non-disclosure of a cause of action held is distinct from a defective cause of action. I have not argued, but this is not my case at all. Kindly come to paragraph 3. We have heard the it's a very short judgment, but it's 4 to 5 paragraphs, paragraph 3. The main ground,
Which paragraph you are referring to?
paragraph 3.
This appeal arises.
Yes, paragraph 3. We have heard the learned counsel, Jageshwari Devi and others. Just look at
No, just a minute. Just a minute. Yes.
highly similar. We have heard the learned counsel, paragraph 3, we have pursued produce the order of the we have also produced the plaint, but the main ground of rejection is what the plaint does not disclose the cause of action, which is the ground. That's not my case. I say there is no pleading about commencement of cause of action. Does not disclose, I never said that. I never argued that. Therefore, whether non-disclosure of cause of action is distinct from a defective cause of action, that's not my argument. This case has no manner of application in the case. And neither they have argued this. Then we'll have the next one, 2021, volume 17, Supreme Court case. That is
Salim Bhai.
Yes. 3 paragraphs, paragraph 9, 10, and 11.
Yes, I've got it.
We can choose, but I am not doing it. But we can choose one paragraph, you just cannot pick it. Kindly see, picking new sentences here.
Dissected. Plaint cannot be dissected.
I also accept that. But kindly consider after on a meaningful reading of the plaint and reading the plaint in its entirety and considering the fact when the cause of action commenced and what's the nature of the claim is based on which fact, then Miller's Lordship will come to this finding whether suit needs to go to trial or not. That's my case.
All right. How do you?
But I will indicate they have cited other 2 judgments, Millard. I'm not referring to this. I will indicate in my notes.
Yes, I got your point.
Fix the date, Millard, after the long Millard holidays, Millard, 24th or 25th. I will come up with a note.
22nd.
Maybe Millard on 20. Subject to what falls from the.
Hardin part adjourned to 24th, you said.
Lordship, on that date, my learned senior friend has also cited some judgments. Since our notes is filed, we'll only file a 1-page supplementary distinguishing the same. That will save the time of the honor.
Liberty is given to file notes of argument to both the counsels.
I'm obliged.
Great.
Item 9.
Mr. Dev, would you come in the second half? Yes, for argument.
We have to give reply, Millard.
For the defendant state, I believe it says.
What is the status of the suit?
Agreed already, Lordship.
But this is a 97 suit. It should not be here.
Lordship, the decree has
24.
তাহলে কিছু চলে এসছে
I have mentioned this. We have heard of fresh schedule, but in the leave of the schedule contains note states a land within the structure. They only generated and marked in red color in the plan. We find out at the time. At the time of drawing of the paper, informed that the plan does not contain in red ink marking. So we have this fresh plan with the red ink marking.
The learned counsel for the plaintiff, that means judgment, a decree holder. Decree holder creates leave to file a fresh plan with red delineation, red marking in terms of
Lordship, there are.
Why it is required?
Lordship, this perhaps is a document appended to the plaint. Matt, the suit has been already decreed.
All right.
A number of appeals.
A plan of what?
Lordship, an application, I believe, a formal application requires to be made, Lordship, because
একটা কাজ করো ডিপার্টমেন্টকে বলো হ্যাঁ
number of appeals are pending.
A report is called from the department as to whether a map of the suit property with red delineation is filed or not. In case it is not filed, the the decree holder is given liberty to file another plan with such red marking. Yes. No further date. Liberty is given to you.
Item number 10.
Intending to change the annexure to the plains, Lordship. By effect of this additional map, the description of the property perhaps will change. I do not know. We have not been put to notice what exactly is being
File an application. Better to file an application. Liberty is liberty is given to file appropriate application. Because right, she is right. We need to know whether it's them or not. Liberty is given the application file now that hearing হবে কি করে 10
That had passed a preliminary decree.
Yes.
On jurisdiction of the suit property, allowing for a special decree matter to carry out the reference for the green property. But
That is not complete.
not completed matter.
On prayer of the learned council, on prayer of the learned council, Mr. Shengupta appearing for the plaintiff, time is extended till 10th June for filing report of the Advocate Commission, Special Referee.
11. Item number 11.
Item number 11 and 12 for the defendant, my lord. Not audible. You're not audible.
What is GA3? WS is filed in both the cases?
My lord, the witness action is going on commission, my lord, by an order dated. The time to file commissioner's report was extended till 1st of April. So I think my learned friend is.
What is 3? GA25, 3 of 25.
I didn't. That has been disposed of.
Appointment of commissioner.
Appointment of a commissioner, yes. That has been disposed of.
GA3 of 25 shall stand disposed of. Time is extended to file report of the learned advocate commissioner. How long would you take? June.
Yes, my lord, because there are voluminous document.
11 June.
Same order for the next item also, my lord.
11 and 12.
11 and 12.
Same. Once the witness action has started, you have to come a fresh application. At this stage, I won't allow.
Yes, sir. But then it was not filed.
What is the order? At the time of evidence, whether that is tenable or not, I don't know.
Let them file an application, my lord. In this way,
Where is the order?
5th April of 2024. 5th April order, my lord. Now it is being filed, my lord. This is. So what, my lord? And I'm objecting to.
I won't allow it now. We file application. After evidence starting of witness action, they'll be taken on surprise. You're certainly appearing with the documents. There is a procedure for this. Come with an appropriate application. For affidavit to what? GA3? Time is allowed to file supplementary affidavit. What is GA3 and GA2? Judgment was passed. You are not aware of this. How long will it take? Weeks time to file AO. The learned counsel for the plaintiff seeks 1 week's accommodation to file supplementary affidavit. The application is adjourned to 22nd April. Supplementary affidavit shall be filed in the meantime.
Item 15, 16 and 17. Sudhir Ranjan Das.
On behalf of the plaintiff, that this is
Intervention application is there.
Application is there, but the suit has been decreed. Post decree, the defendant had filed an application.
What is that intervention application? Who is for the intervener?
I'm for the intervener, Lordship.
After decree, what will you do?
Lordship, the decree was passed in sometime in 2016, Lordship. After
that, it was decree. After passing of the decree,
Before
this
drawing
property
up-
was sold.
Lordship, before drawing up of the decree, Lordship.
Before
the
drawing up.
application for cancellation of the decree was filed by the defendant in the suit, Lordship.
Post drawing up, but before the decree is finalized, application was moved. There, an order was passed directing the parties to maintain status quo. Notwithstanding that status quo order, the defendant has transferred the property. And not only his share, claiming to be his share, he has transferred the entire house.
Now, Lordship, this was in 2016.
Right.
The application was filed.
What is the intervention application?
And intervention application is 2025, Lordship. I have
What is the name of the number of the application?
GA8, Lordship. GA8 is the intervention application.
What is GA7?
GA7 is an application filed by the plaintiff's lordship where they have challenged my deed of conveyance and they have sought for cancellation of my deed.
Once the thing is done, let it be heard.
Lordship, if I am allowed, Lordship, then I'll have to take an opposition to this GA7, Lordship, until my application.
Let your locus standi be decided first,
Lordship,
then
Lordship.
opposition.
Yes.
Not now.
Of course, Lordship. Grateful.
Lord, kindly see your lordship's last order dated 17th March 2025. Or affidavit.
Now, so far as intervention application is concerned, I am hearing that
Very
firstly.
kindly, Lord, take it.
I have heard this application from you after passing of the judgment and before the finally decree is drawn up.
No, decree has been drawn up. Only, Lord, the finality of the decree could not be given because, Lord, the defendant, Lord, moved at that stage. The defendant moved the court at that stage, and court said that maintain status quo, including status quo with regard to the property. The parties were asked not to transfer or alienate or encumber. That is the situation that we are. And this transaction which has happened, Lord, it is post the order of the court, and therefore, Lord, I was compelled to move this GA7, which was entertained by your lordship, and you, my lord, had passed an interim order.
Now, so far as this intervention application is concerned,
yes,
what is the locus standi of intervener?
Absolutely none.
Because once the judgment is passed,
yes,
we have to reopen it.
The gentleman is claiming to have acquired some interest through the defendant. This is a devolution.
Yes, yes.
This will not come, Lord, under Order 1, Rule 8 or Order 1, Rule 10. This will, Lord, come under Order 22, Rule 10. And under Order 22, Rule 10, Lord, there has been no devolution because, Lord, defendant has in the meantime filed a suit in the Alipur court. And he is saying that it was a fraud on him to have executed this document, he has asked for cancellation of the document.
This intervener.
The document executed in favor of the intervener, there is a suit between the defendant and the intervener in the Alipur court. Where, my lord, the defendant has a plaintiff, has filed a suit seeking cancellation of the document.
No, first question is
Yes.
when the judgment is finally delivered.
There is no question of, Lord, adding an outsider as a party in a suit for partition which has been decreed. There is no question the court loses jurisdiction to add anybody as a party once the decree is passed. Whether the decree is going to be reopened or not, that's a different question, because that is the issue, Lord, pending consideration before your lordship in the application filed by the defendant. If your lordship allows the suit to be restored, then, Lord, question of further consideration of intervention application might come in,
Where
because
is defendant's application?
defendant's application is
That is GA 1215 of 2016.
yes, 1215 of 2016.
That was only kept pending.
Yes, Lordship. There's an
That they have not moved after that. After that fast
there's
order.
an order is 16th June 2016, Lordship. There's an order which is
There was the settlement decree. Decree was found in terms of settlement.
Settlement.
now, Lordship. This
Next order. Can you see this order? Date of this order. 13 March 2015. Next statement, order because 16 August 2015. August. Finally, our argument.
Argument.
Decree dated 8/9/15 on the basis of terms of settlement dated 29th August 2015.
Can you see the appeal? Can you see the appeal?
We shall see.
Page 25. Page 25.
25 is the part settlement. He has not challenged that part settlement. He has signed the terms of settlement. What is he saying?
Lordship.
Otherwise, I am not
Accepting.
Lordship, in GA 1215, the defendants have claimed that they have not consented to the terms of settlement. It was signed by the signature was taken with by misrepresentation, Lordship. That is the averments in GA 1215, Lordship.
Lord, my learned friend hasn't
All right.
been mandated as a
Liberty
party
is given
yet.
to Mr. the learned counsel for the defendant to file wakalatnama. GA 1215 of 2016 is filed by the defendant praying for assailing, filed by the praying for cancelling / setting aside the terms of settlement dated 29th August 2015 along with other prayers. This application along with GA 8 of 24 as well as GA 7 of 24 shall be taken up together on 22nd April.
Lordship, my intervention application, Lordship.
Let this be filed. Let this thing be done.
No, Lordship, only one thing, Lordship. GA7, Lordship, that has been filed by the plaintiff. The prayer in that is for cancellation of my deed of conveyance, Lordship. My only prayer is that may be not heard behind my back. If I am added a party at all, my intervention application be at least
That
heard
she
for.
has no right of hearing in terms of Section 22 of the Hindu Succession Act. He has no right of hearing.
22nd April 2025. This much.
Lord, the interim order, my lord, may be extended.
Interim order be extended till date. Mr. Kaur, wait please. There is one problem, technical problem.
My lord.
Only this application, that is GA 7 of 24,
yes,
is part heard.
Yes. GA 8 is also
not part heard.
GA 8 was part heard.
7 and 8 both are part heard.
6 is not parted.
Lord, 6 is not.
GA 12.
Huh? 1215. Oh, no, 6 বলছি। Oh, আচ্ছা ওটাই 1215. Oh,
I
Lord,
cannot pass
that-
order in 6.
no, but that has to be heard first because unless Lord
I
you.
cannot hear this
Oh, I see.
because I have no determination to hear these suits. I can only hear the applications.
Lord, this is an application Lord in the nature of
Suit,
order
I have no determination to hear the suit.
But this is an application in the suit. This is not a.
Maybe, but I have the suit is gone. Only applications are parted. That's why it will be retained.
Oh, I see. I see. তো তাহলে কি করবেন? Because that has to be heard first.
Orderটা কেটে দিন তো পুরোটা।
Then Lord.
One thing I can do.
Yes.
I am keeping a date.
Yes.
For hearing these two parted applications.
Yeah.
You may get it released. Or otherwise, I will release these applications also for hearing in a single bench.
Lord, so far as the parted applications are concerned, kindly keep it with your lordships. Lord, we will try to, Lord, kindly release.
I should not say this. Get it transferred to my court.
No,
rather, I
no,
can
no.
say I can release.
As I said, Lord, there are the applications are interconnected. So therefore, Lord, we will Lord make an appropriate application so that Lord the third application can also Lord come.
শুধু এইটুকু দেখুন GA 7 of 24 GA 8 এ parted order আছে দেখো তো।
হ্যাঁ, both are.
GA 8 of 24 shall appear in the list for further hearing on 22nd April. Since these two applications are parted, the rest of the suit along with GA, the suit itself along with GA 6 of 16 is released for placing before the court, before the bench, having proper determination. Otherwise, I cannot take it up. Otherwise, I cannot pass any order.
Lord, we'll take appropriate steps. I'm much obliged to you.
18.
My application for substitution, my lord. The defendant company's name has changed and the registered office of the defendant company has also changed, for which I have made this application, my lord.
Who is your other side?
I'm
From India Bulls to?
It has changed from changed to India Securities Limited. It was initially known as India Bulls Ventures Limited. Thereafter, it got its name changed to Dhani Stocks Limited. Thereafter, again, it got its name changed to India Bulls Securities Limited.
Where have you stated this?
My lord will kindly come to.
Proposed amendment. Where is proposed amendment?
Annexure X, my lord will kindly take up.
The instant application is filed. Who is the defendant?
My lord, I am appearing for India Bulls Securities Limited. My lord, this is not a case of simply changing the name of the company. My lord will kindly see paragraph 4 of the affidavit in support of the master summons. My lord will find at page 3 that the defendant in the suit had transferred its business to India Bulls Securities Limited, my lord.
Yes. Here it's a prayer for amendment. I can allow it.
My lord,
No issue. Here, patience. Have some patience. Now, if it turns out at the time of evidence that things are different, no decree will be passed against him, passed in his favor.
I'm not opposing the prayer. I'm only saying that the grounds which have been mentioned in the application are not correct, my lord.
It's not change of name,
my lord.
So you have to file appropriate application then.
In my humble submission, my lord, I had come up with an application for amendment. Then it was a submission that it cannot be amended because this has the business has transferred from this company to that company, so it has to be a application for substitution. Now that I've come up for an application for substitution, he says that no, the name has not changed. There is that business transfer agreement, so not substitution. It will be amendment. It cannot.
I'm not
he
saying
cannot
there is
blow
no
hot
change in the
and
name
cold.
of the company. What I'm saying is that there was a transfer of the business and thereafter the name of the company had changed.
Even if the business has been transferred, the transferee company has taken up all the assets and liabilities of the parent
that
company.
letter is, look, that letter is here.
My lord.
Here it is stated that entire broking business is transferred to India Bull Security Limited. So for abundant precaution, I cannot say whether this is the new person, whether this person is non-existent, whether by with simple amendment this can be done.
My lord,
Better you file with an application under Order 1 Rule 10, I will add it. That will solve your problems.
I have made an application for substitution because in my humble submission, even if it is a
then file with substitution application.
But this is the substitution application.
No, this is amendment, I think.
But will kindly come to the prayers, my lord. The original side we do not write the provisions of law, my lord. Prayer A for substitution.
Substitution. Change that. Yes, what do you have to say?
My lord, in para number 6 of the affidavit, they have pleaded that although the names of the defendant may have been changed, the corporate identification number of the defendant remains the same.
So what do you want to say? Should I dismiss this application?
No, my lord. The ground which they have taken is that there is only change in
wrong
the
ground. Maybe wrong ground.
I'm not opposing the prayer, my lord.
GA 4 of 25 is filed in view of change of business transfer to India Bulls Securities Limited. Full stop. This came to the knowledge of the petitioner, learned counsel, in terms of the letter dated 29/11/2024. This application is filed praying for substitution as well as amendment of plaint. Let prayer A and B of the master summons be allowed. Department is directed to do the needful. For further order, the suit will appear in the list on 1st May.
Not only one indulgence. After the amendment is carried out, the amended copy of the plaint be served upon.
Definitely. That's why for further
My
order.
lord, kindly record it in the order, my lord.
No, not now. Let this be done first, then I will pass order. Disposed of.
19 and 20.
I appear, my lord, virtually if I leave may be given, my lord, in this 19 and 20.
So I am appearing for one of the intending purchasers of the property.
Let this be disposed of first.
Well, the question of purchase does not arise because here.
No, I am not hearing it. I will hear your application. I will pass order in your application, whether allowing or rejecting. Then other matters may be taken up.
My lord, that
So I am
my lord has
reserving it
made
for
it
order.
very clear. That my lord has made it very clear.
What is your application?
My application is for addition of purchase.
GA number?
GA number 1 of
देखिए
2023.
GA number 1. Hearing in GA number 1 is concluded. Reserved for order. Let it be reserved for order.
My lord.
In the order itself, I will mention the next date.
Deeply obliged. So it will come up as a judgment, my lord, any day.
No, not
subject to my lord.
judgment. It is order. Why
Order.
judgment?
So it will appear as for orders in one day, my lord, or?
Yes. I am not fixing any date. You will find it.
My lord. Deeply obliged.
21.
My lord, I hope, my lord, today, my lord, the issues will be framed. This is what I can expect.
Defendant number 5.
Last 3 days, my lord,
I will frame issues.
my lord, let me hand over. Only one
My
defendant
lord,
who did not.
I'm appearing for
Just
defendant number 2
wait, madam.
virtually,
Just wait. Let
and
me.
he had handed over.
My lord, on the last day, my lord,
Yes,
I
yes.
came up with a suggested issue, and only one
Discoveries,
defendant did not
inspections,
come
all these things are complete.
So far as we are concerned, I think it's over. Mrs. Ghosh's client and
Yes.
we are concerned, it's over.
5
also.
Yes.
For different number 5 files, admission and denial of document, that the same be kept in record. Judges brief.
My lord, I am
Legal
also
action has
filing
to commence.
affidavit of admission and denial for 1, 3, and 4.
Different number 1, 3, and 4 also files admission and denial of document, that the same be kept in record.
My lord, I'm sorry, my lord. Judges brief of documents have not been filed.
Judges
but
brief of document.
on the next day, when Lordship will, my lord, fix a date for witness action or framing the issue.
Let this judges brief be filed first, then issues
Very
will
well,
be framed.
very well, my lord. So kindly
Judges
record
brief of
all parties
document
have filed their.
shall be filed
My lord, we are also filing our
On
suggested issues.
22nd April, issues will be framed on that date.
My lord, kindly record
But
that
so
all.
far as defendant number 2 is concerned, we have already submitted our suggested issues on the
Now on the
last
next date,
occasion.
let judges be filed.
Yes.
My lord,
Yes.
only one thing would your lordship record, my lord, that all parties have filed their respective suggested issues, my lord.
Need then become on the next
Very
day.
well.
I
Very well.
mentioned that.
Let my lord 2017 matter. My lord, I know. My lord.
22nd April.
Yes. For framing of issues, my lord. And on that day, my lord, we will file the suggested judge's brief of documents and lordship will fix the date for commencement of the witness action. I'm grateful, my lord.
Give us sleep.
My lord.
Give us sleep.
Yes.
Mentioning your name.
Yes, that's very important.
That's very important. It will be there.
So all of us, we have filed it.
22.
Grateful.
Item 2.
Suggest liberty is given to the learned counsels to file suggested issues if not filed.
All filed, my lord. All are appearing, all filed.
You have to file.
5 have to file only. Then
If
again,
not
there will
filed.
be, my lord, another date, my lord. Kindly,
That
my lord.
I have specifically mentioned on that date, I will frame issue.
I'm
Whether
grateful.
it is filed or the suggested issues are filed or not, I am only waiting for judge's brief of document.
Absolutely, my lord. On that day, we will come, my lord. I'm grateful to your lordship.
22.
22 for the plaintiff. But, this is today not fixed for framing of issues, but that I was directed to file judge's brief of documents. Could not prepare it.
Judge's brief of document is yet to be filed.
7 days time we will.
Adjourned to 22nd April.
22nd. Grateful.
May please your lordship.
What is
my lord,
GA9?
GA9, my lord, is my application seeking reimbursement of certain expenses which I have incurred while I was administering the estate.
Who is
prior-
administrator pendentity?
Ms. Piali Shengupta. On
She is not here?
On the last occasion, my lord, your lordship had been pleased to pass an order directing her to file a supplementary report. She had filed a report, but the total aggregate sum which she had found due and payable to me was not mentioned in the report, which is why your lordship had been pleased to direct her to file a supplementary report on or before.
Where is the
1st of April.
supplementary report?
That, my lord,
Supplementary report is yet to be filed. The learned administrator pendentity shall be personally present on the returnable date. Let the matter appear in the list on 24th April.
my lord, kindly give me- my lord, maybe give her a notice also.
A notice of a copy of this order may be communicated to the learned administrator pendentity by the learned registrar original side.
My lord, my learned friend in some difficulty on the 24th. Could it be any other date, my lord? 20.
28th April?
20th, my lord. Grateful.
24. Item number 24.
Not today.
Not this week.
Not today.
Not this week.
25.
I'm on behalf of the petitioner, Your Lordship.
What is the
On the last occasion, Your Honor has
no application is pending?
Can you refer to the order dated 7th March 2025? The court, this honorable court has directed discovery.
Why this is number as CS.Com 112? Was it transferred at any point of time?
No.
Then it must be.
I think it was wrongly numbered.
No, must be. And then retransferred.
No, all throughout we are appearing before this honorable court.
Then why CS.Com?
Probably.
The learned registrar IT shall make correction in the name, in the number of the suit, keeping in mind that this is not a commercial suit at present. This is not listed in the commercial as a commercial suit.
My lord,
Yes.
it is renumbered as CS 31 of 2024.
This should no longer be there. This CS.Com number.
My lord, as per the last order.
Discoveries inspections.
Yes.
Is it done or not?
No, not yet done. Yesterday they had fixed a time. I had visited the office, but they are showing me the photocopies of the documents. That is not the compliance of the order.
Next time it should be complete, otherwise your defense will be struck off.
Your Lordship, the
Your
original.
Honor, I just request you to refer to the order dated 26 July 2023. If you allow me to read that portion of the order. there they said on that date, almost a year back. No, this is almost 20.
Discoveries and inspections of document is yet to be complete. Peremptorily time is allowed. Let it appear in the list on 22nd April. In case discoveries and inspections of documents are not passed, are not done, adverse order may be passed.
Your Lordship, the original documents have been seized by the police officer and it is still with them. We are unable to take it back from them. And the original documents has also not been marked as exhibit in this
In
matter.
that case, you have to file appropriate application that
will
these
file the
documents cannot be made as of now.
Your Lordship.
You must have some copies.
Yes, we have the photocopies of the documents.
That's all. You come with an affidavit that we have done this.
Already, Your Lordship.
My lord, one humble submission. Order dated 26 July 2023 records the plaintiff has applied for certified copy of the said documents.
You are
so that
defendant.
the same can be disclosed. Yes. So that the same can be disclosed to the defendant for inspection.
Yes.
Since July
Your Lordship,
2023, please allow me to say. Since July 2023, this inspection, they have committed on that day. Now we are in 2025. We paid.
This application of certified copy is pending.
Yes, Your Lordship.
Now you must have copy.
We have the copies. The
Show the
photocopies,
copies.
it is in the judge's brief of documents, Your Lordship.
No, that is different. That is a photocopy. Certified copy will produce. It will
Certified copies
Defaced with
can
stamp.
be produced at the time of final
But
hearing.
that was not a certified copy. That was a simple photocopy.
Maybe we check it, because if the certified copy is not obtained by them, if the certified copy application is pending, how they can be blamed?
No, let them produce that they have filed it and it is pending.
Have you filed any application? Then show that.
Your Lordship, I have to take instruction on that.
But the same
Not
thing is
only
going
instruction, not only instruction. I will pass orders striking out the defense. You will be affected if you are not vigilant enough
So let it be
to guard your interest. You are coming before this court and saying every day I am taking instruction. Adverse order will be passed, and in fact we are plaintiff. The suit will be dismissed.
last occasion, Your Honor, have directed them that adverse order will have been passed, but that was not recorded in the order.
I will simply dismiss this matter. I will just wait for this.
Right.
You have to take guard of your own interest.
Yes, Your Lordship. Your Lordship, there is also an application pending which for the
Let this be
deletion of
done. Let it be decided whether this suit will remain or not, then other applications.
Another important point is the defendant number 1 has died. We have intimated them within time. But
Let
no
them do
steps have
whatever
been
they like,
Lordship,
come on the next date.
we have already filed that application, but due to some errors in affidavit of competency, we have filed the proper affidavit of competency
Do
before
whatever
the,
like. Let the application
before
come.
the
We will
department
see
has
whether
announced
it's
the
submitted or
final.
not. And I'll pass order. Simply this much.
much of it.
Okay.